about our responsibility as employers. So good morning, OCASI membership. It's always wonderful to have us all gather together. We don't often get an opportunity to see each other from across the province. Now that the vaccine rollout is happening, I believe yesterday I heard that 75% of Ontarians have had their first shot and about almost 25% have had a second one. We've just opened at stage 1. We held a series of regional meetings a few weeks ago, and we heard in every region that your preoccupation was about return to work and what your obligations and responsibilities are as employers. So very pleased that we're able to have this conversation with you this morning with Dilpreet, Grewal, and JPak, who I will introduce more formally later. I want us to begin by acknowledging the land that we are on, the traditional territories or the peoples of Turtle Island. The sacred land on which we are gathered today has been the site of human activity for 15,000 years. We acknowledge the land we are meeting on is a traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples, and is now home to many diverse First Nations, Inuit, and Métis peoples. This territory was the subject of the Dish with One Spoon, Wampum Belt Covenant, which is an agreement between the Haudenosaunee and the Ojibwe and allied nations to peaceably share and care for the resources around the Great Lakes. We also acknowledge that Toronto, where I'm speaking to you from, is covered by Treaty 13 with the Mississaugas of the Credit. I often take this opportunity as well to recognize that we're all treaty people. Many of us who've come here in this generation and in generations past, I especially want to acknowledge my own ancestors who have been here on this land for the last 400 years as an enslaved people. I am thankful for their survival so that I can be sitting here with you today. Just a few housekeeping items. We ask you to keep yourself muted in an effort to get the clearest sound without any disruptions. Please feel free to use the chat box to communicate and ask questions. I will be checking the chat box as well as Selena. So we will try and get to as many of your questions as possible. We are being simultaneously translated in both official languages. So for those of you needing French, at the bottom of your screen, there is an interpretation box. If you click on it, you can choose either English or French. So this is for whichever language you prefer to participate in. The format will be a presentation by Jonquille, followed by Q&A, and Dilpreet, who is a colleague of Jonquille, will be joining as well to answer your questions. So let me stop talking and get to our two dynamic presenters. JPak is a Toronto labor and employment lawyer with over 12 years of expertise. Prior to founding JPak Employment Lawyers, Jonquille worked at two of Canada's top labor and employment law firms. She has represented unionized and non-unionized clients in a wide variety of sectors, including manufacturing, education, mining, and small startups to large blue chip companies. Called to the bar in 2007, Jonquille has successfully worked with thousands of clients in connection with labor and employment law disputes with favorable decisions at the Ontario Supreme Court, the Federal Court of Appeal, various labor arbitration boards, the Ontario Labor Relations Board, the Ministry of Labor, the Workplace Safety and Insurance Board, and the Ontario Human Rights Tribunal. Welcome, Jonquille. Jonquille is joined by her colleague, Dilpreet Grewal. Dilpreet is a labor and employment lawyer who always goes the extra mile for his clients. Understanding that no two cases are alike, he takes the time to know his clients' priorities and to develop a client-centered strategy. Dilpreet appreciates the challenges parties face when the employment relationship breaks down and aims to achieve an early and fair resolution whenever possible. His years of experience as an insurance defense lawyer and representing large organizations gives him that strategic edge when representing individual employees. He began his legal career as an insurance defense lawyer, where he litigated complex personal injury, disability, and motor vehicle accident benefits claims on behalf of a variety of government ministries. Dilpreet earned his law degree from the University of Manchester in the UK. When he was not hitting the books, he volunteered his time at the university's legal advice clinic, where he provided pro bono services to vulnerable individuals. Before law school, Dilpreet completed his undergraduate degree at the University of Toronto with a major in philosophy. He was an active member of the student community and held office in student government. Dilpreet, welcome. Jonquille, the floor is yours.
Thank you. And I'm going to share our screen so you can see our presentation deck, which we will make available for the audience as well. Can everyone see that? Okay.
Yep.
Dilpreet?
Good morning, everyone. Thank you for joining us today, to both our English and French listeners and viewers. So today we're here to discuss what I'm sure many of you are concerned about, is the role of vaccinations, return to work, what employer obligations are going to look like as we approach the later stages of reopening and hopefully eventually a full reopen. Before we get into it, I would like to point out that quite a bit of what we're going to discuss today is somewhat speculative. The government has given some direction on where things are going, but it's changing on an ongoing basis. They're adjusting according to the needs of the province. So do be mindful that you will need to stay regularly updated, and they are actually regularly updating their regulations to inform the public on what their obligations are. And likewise, anything that we discuss today, because of the nature of what we're discussing, is for information purposes. But if you have any further questions or require something more substantive, you're more than welcome to reach out to Jonquille or myself, and we've left our emails there for you. Next slide, please. Okay, so it probably is a little helpful to do a general overview of what we're going to discuss today. We'll start by just going into the current state of affairs, what's going on, where the province is at right now. We'll segue into the Occupational Health and Safety Act, which is going to substantively discuss what your obligations are in terms of providing a safe working environment for your employees. Then we'll go into the vaccines, what's been developing on that sphere, where does it look like it's going, and of course, related to that, whether you can ask your employees to do it or force them to do it. Enforce being a very powerful word, but there's some nuance there that we are going to discuss. Likewise, if you can ask your employees for proof of vaccination, of course, you might be concerned about the health and safety of your workers and yourself, of course. So you will want to know who's been vaccinated. We'll discuss that. Work refusal. So this will be a big one. People who come back to work or decide not to come back to work, and they may take issue with doing certain tasks in certain environments out of safety concerns, how to engage those conversations, who can be accommodated, who doesn't need to be accommodated, what sort of practical steps employers can take. Then the workplace health and safety insurance. So this is a lot of the WSIB sort of thing. Individuals who might have gotten COVID, how that connects to what kind of compensation or insurance that they might have access to. And finally, we'll tie off with questions from all of you, and hopefully we can do our best to address any of your concerns. All right, so as many of you will definitely know, we've all been locked indoors for quite some time now. The lockdown unexpectedly extended itself, and we only recently got to see the light of day. But many of the restrictions that we're looking at seem to still be in force. It's still very, very restrictive in terms of what we can do, where we can go, how we interact with general public and even our loved ones. So in my most recent review, it seems like Ontario has hit about 500,000 cases, with about 9,000 of those cases resulting in death as a result of COVID. But on June 11th, 2021, the province provided its roadmap to reopening, which is the general plan that the province has in place on the stage process to eventually get to the point where we can all go back to normal, or whatever the new normal will be. So the reopening will happen in 3 stages. I will discuss that in more detail as we go through the presentation, and some of the changes that may be staying in the long term, some of those that may go away more quickly than others, and we'll get into that. So I will flip back to Jonquille on this topic.
Okay, so switching gears. So we're going to be taking a look at what are the overarching obligations on the part of the employer to ensure worker health and safety in the workplace. Now, with respect to an employer's obligations, there are generally 2 sources of our laws. There's the common law, which is court law, court decisions on what employer obligations are with respect to the standard of care that's required for worker health and safety. And then there's also legislation. So the 2 statutes that are of importance to employers to note are the Reopening Ontario Act, which deals specifically with the various stages in which employers can reopen. Okay, and it will set out very sector-specific guidelines. And then there's also the broad health and safety obligations under the Ontario Occupational Health and Safety Act. And so it's that piece of legislation that sets out the overarching obligations on the part of the employer, which I'd like to review with you. So the Occupational Health and Safety Act applies to all provincially regulated employers in Ontario. There are a few employers that are federally regulated that would fall under the health and safety provisions of the Canada Labor Code, but that deals only with federally regulated enterprises like banking, telecom, railways, airlines, etc. But the vast majority of employers in Ontario would be provincially regulated and would fall under the Ontario Occupational Health and Safety Act. And I expect that most, if not all, of the attendees today fall under the Occupational Health and Safety Act. Now, under the Occupational Health and Safety Act, there are no COVID-specific provisions. It sets out broad, overarching obligations on workplace parties to ensure health and safety in the workplace, and that includes employers, supervisors, and employees. And it sets out substantive duties on the part of the employer, and that includes the duty to take all precautions reasonable in the circumstances to protect worker health and safety, to conduct risk assessments in connection with workplace hazards, including the risk of COVID-19 transmission. It also creates an obligation on the part of employers to create and disseminate workplace health and safety policies and procedures, and to ensure that staff are complying with workplace health and safety policies and procedures. It also requires the employer to ensure that workers know about known hazards by providing necessary instruction and information and supervision to employees to ensure that they are working safely. It also requires employers or supervisors rather to know what is required for the protection of employees under their supervision, and to ensure that workers are provided with personal protective equipment, or PPE, when necessary. And the legislation also creates a duty on the part of employers to consult with joint health and safety committees. That depends on the size of the workplace, or health and safety representatives, and where applicable, the union who represents employees in the workplace. And it creates an obligation to seek their input on issues like potential transmission in the workplace and how COVID-19 risks can be minimized. In terms of the enforcement of the Occupational Health and Safety Act, it's generally enforced through the Ministry of Labor that deploys inspectors. And Ministry of Labor inspectors have a right to visit and attend at any workplace premises to verify health and safety compliance. Now, inspections are typically complaint driven, so it could be a worker specifically filing a complaint with the ministry, or it could be an anonymous tip. But the Ministry of Labor can also conduct spot audits. And the ministry does conduct inspection blitzes, typically focused by sector. So for example, they may focus on big box stores, retailers, and generally they would publish that information on the Ministry of Labor website. And then what's interesting is that the Ontario government has announced in March 2021 that it hired over 100 additional OHSA inspectors, so bringing the total number of inspectors to approximately 500, which is the largest apparently in Ontario's history. So what are the types of things that can happen on an inspection? The inspector can issue directions requiring an employer to take certain measures to comply with the Occupational Health and Safety Act. They can also issue stop work orders, effectively stopping operations until compliance with the legislation or regulations are met. They can also issue provincial charges to any workplace party that's determined to be in violation of the Act, and that includes any entity, officer, director, employee, or supervisor. And there are hefty penalties for non-compliance under the Act. So charges upon conviction can result in hefty fines. So for an individual, that can be a maximum fine of $100,000 or imprisonment of up to 12 months. The maximum fine for corporations is up to 1.5 million. Now, these are maximum fines, and it'd be very rare to see fines of that magnitude or jail time, but there are significant fines that can be levied for various infractions. Now, with respect to COVID-19 specifically, to date, according to the Ministry of Labor statistics that were recently published, there have been over 13,300 COVID-related workplace inspections since the beginning of 2021. 9,480 orders issued to employers, 373 tickets issued, and there have been stop work orders on 15 occasions. Now, health and safety is not implemented in a vacuum. So while the primary obligation for worker health and safety rests with employers, employees have joint obligations under the Occupational Health and Safety Act to report hazards to the employer, to wear personal protective equipment or PPE as required, to follow health and safety protocols and procedures, and to report any occupational illness or workplace hazards to the employer. Now, I want to draw your attention to a couple of recent labor arbitration decisions that deal with the issue of worker compliance with COVID-19 related protocols. There's a recent decision involving Garda Security. It was a 2020 labor arbitration case. Garda is a security services provider. It's a unionized employer. In this case, the Grewal, a security guard, was fired for failing to comply with COVID-19 protocols, and the union grieved that dismissal as being unjust and in breach of the collective agreement. Now, on the facts, the employer did have a policy that required that if an employee was waiting for COVID-19 tests, they were required to quarantine. And in this case, the employee in question had actually taken a COVID-19 test due to possible exposure. And while waiting for the test results, she decided to report into work. Even though she, in this particular instance, she had no symptoms at all, but she was waiting for her test results. And ultimately, it turned out that she did test positive. And the employer terminated her for cause for reporting into work in violation of their COVID-19 protocols, which said that if you're waiting for a test, you can't come into work. And she just pleaded ignorance, saying, I didn't know about the protocol, and the employer wasn't buying it in this instance. And ultimately, the arbitrator reviewed the nature of the infraction and upheld dismissal for cause in this instance. And in the arbitrator's view, the fact that she was not feeling sick was totally irrelevant. In the arbitrator's view, her actions amounted to a clear violation of well-known public health guidelines and employer protocol. And she should have, in this instance, self-isolated for the protection of other workers, including all of her co-workers. And in the arbitrator's view, her conduct put countless others at risk of illness or death. And that's interesting, because there's another case that's not referred to in this slide, but that follows the same thought process. And this is a case also in 2020 involving La Una, the union in Icon Industrial. And in that particular case, the employee was also similarly dismissed for failing to follow COVID-19 protocol. In this particular set of facts, the Grewal was a construction worker at the Darlington nuclear generating station. And the Grewal was scheduled to work, but called his foreman saying that he was feeling ill, under the weather, is having stomach issues. And the Grewal was told by his foreman to stay at home, wait to hear from the company nurse about whether you're coming in, because your stomach issues do appear to be a symptom of COVID-19. And so he called back twice, and the employer each time just said, look, we'll contact you, don't attend the workplace. In the meantime, he hadn't heard anything. His stomach issue resolved, but he developed a runny nose, but he chalked that up to his allergies. And then, he wasn't entirely sure, but he hadn't heard from them. So he erred on the side of reporting into work, even though he hadn't received a call back on whether he was cleared to return to work. And on screening, the employer asked various questions, including, do you have a runny nose? And he answered no. And he answered no in the negative to all health-related symptoms that are associated with COVID-19. And he didn't tell the screener in that instance. He was actually waiting to hear back from the employer about whether he was cleared to return to work. It turned out he wasn't cleared. As soon as the employer found out that he reported to work and breached a protocol, he was fired for cause. The union grieved it. And the arbitrator in this particular case also upheld discharge, saying that he deliberately failed to report a COVID-19 symptom. His behavior and his infraction in this particular case was totally unacceptable in the arbitrator's words, and that he created a, quote, dangerous situation by attending at work, potentially exposing his colleagues to risk. And so the arbitrator characterized in this instance the griever's attitude as a deliberate and cavalier infraction and a cavalier attitude towards health and safety. So I think the key takeaways from these arbitration cases are that failing to follow COVID-19 protocol is just cause for discipline and possibly cause. Now, in this case, cause for termination. And in this case, the griever or the arbitrators rather upheld discharge in both instances, but that doesn't mean that in every single case that an infraction of COVID-19 protocols will automatically amount to cause for dismissal. That's always very context specific. And you'd have to look at a variety of mitigating or aggravating factors, but certainly the early jurisprudence that we're seeing is that they are weighing it heavily of serious discipline for cavalier violations of COVID-19 protocols. Slide.
Okay, so on that note of health and safety, I guess it's important that we just briefly go over some of the ways that you can mitigate risk within your workplaces. So the most important thing I'd like to impart on everyone here today is that every workplace is different. This is going to be very, very, very contextual. What will be reasonable in one workplace might be completely unreasonable in the second workplace. A great example for, if you're an ECE, an early childhood educator, for example, working in a daycare, and you have to deal with children all day long, it's very difficult to maintain social distancing and even get the children to social distance from one another. What will be required of you in terms of an employer making sure that this is a reasonably safe workplace is going to be vastly different than, for example, an open air construction site or someone who works in the forest. So there's a whole spectrum. I know many of you probably fall somewhere in the office range, so we'll discuss that more in detail, but that's just to give you a sense. So, your level of risk is mitigated by how you can use these different methods of reducing the risk of COVID spread or contraction at your workplace. One of the most common is more or less encouraged / somewhat mandated by government right now is work from home options. A lot of employers have embraced this, some more than others. It really depends upon what's practicable. It depends on whether your business can function that way. You'll have to, it's a weighing. So some people might completely work from home and an employer might say, you know what, my lease is up, I'm shuttering my doors. Others might want to do more of a mixed environment to lower the number of people who are at the premises. And likewise, there might be some employers who absolutely can't do without their employees coming in. So you can use the other factors to mitigate against whether you can accommodate work from home. Physical distancing, same idea. I mean, we do this day to day everywhere we go. People stand in lines, everyone's got to be 2 meters apart, that sort of thing. Whether people comply with it or not, we'll leave that open to your personal experiences. But insofar as your concern as an employer, if you have a really small office and you have 10 employees, in order for you to social distance everyone, no one could be more than 4 feet away from each other. Well, they're not very much social distancing, are they? So you have to take these sorts of considerations. So maybe in a way of working around that would be to have certain employees work from home certain days. You do rotating shifts, you take different alternatives, maybe some continental shifts. They don't overlap as much, nights or days. It really depends on the nature of your business, but there are ways of working around it. Vaccine availability is more of a new concern. And that goes into the stages that we're going to talk about. But as far as things look right now, they're reasonably available. They're going to continue to be reasonably available. And hopefully we have substantive vaccination come fall. But you can also consider where your workers live or where your business is. So, the Greater Toronto area or wherever you might be, I expect that many people commute into work. Now, I'll use the Toronto area as an example. If you have employees coming downtown from, let's say, Peel region, obviously it's a very hot spot sort of area for COVID. You may want to have a greater sensitivity to the employees from there coming in because they're a greater risk to your space, versus someone who might live a little more rural where it's not as big of a deal for them. The risk of that person coming in is less so. Likewise, it could be the flip side in terms of vaccination. The person living in the rural area may not have more immediate access to vaccination, whereas the person in Peel might be getting it much sooner. So these are sorts of considerations that you can take into your assessment of, as vaccination continues, especially if you do need people to come in right now and on a continuous basis. And of course, your business, what is the level of interaction with the public? Is this just everyone sits in an office, no one's coming and going? Do people have to regularly come in? Do you have outside consultants, clients, etc., guests? You'll need to consider the amount of interaction, kind of flow of people in and out of your buildings, your workspaces. You can also take stock of who's vulnerable. Who do you know who has told you that I have a vulnerability to COVID? There's some general guidelines out there about, age groups, people with pre-existing conditions, that sort of thing. You can take those things into account into managing the risk, especially for the people who are the most likely to have the most adverse effects from getting COVID. The history of workplace transmission. If you even had a single COVID scare, or if you're in a workplace where, because of the high degree of interaction, there have been cases in your workplace. If you see any patterns emerging, work around those patterns. If you see, for example, people who work for you who come from a certain location tend to bring the COVID into the workplace, use that as a bit of a workaround. Or if you see that people in your office seems to be transmitting in a certain environment or in a certain way, and you're playing around with your workspaces, what kind of PPE you're using, the degree you're using that PPE, it can be indicative of where your vulnerabilities are. So it's something to consider. You may not see that, but it's good to have in the back of your mind. And of course, going to the locality issue, we already discussed certain regions will probably be heavier than others. So community spread, being aware of community spread, having a general sense of where the vulnerabilities are in the province is very helpful in terms of building your strategy. Yeah, so just branching off what we were already discussing. So these are some examples of things that you can do: social distancing, protective supplies, making sure you maintain regular sanitation of your workspace areas. I'm sure you've seen some traffic flow direction when you go to the grocery store, arrows telling you which way to follow. You see a lot of that in most buildings now. Certain stairwells are even built that way so that, one stairwell is dedicated to going upwards, one stairwell is dedicated to going downwards. These are little things that you can do to help at least steer people from bumping into each other too much. Plexiglass has been very popular too, especially in environments where you don't get the opportunity to space as much. This is something that you can do to create a bit more of a barrier between individuals, help mitigate the risk. Screening, which we'll also discuss later, and how that might look in the future. Capacity restrictions are another way of dealing with this. I'm sure you'll notice that everyone's had to wait in long lines at Costco because there's a limit on how many people they'll let in at any given time. That's one way that they hope will manage some of that. We've discussed mixed remote in-person work, staggering shifts, and yeah, of course, prioritizing employees who are from lower risk regions. Okay. So I would like to point out, I think that was the right slide. No, if we can. Sorry. That's correct. Thank you, Jonquille. You were right.
Sorry. Okay. All right.
It's okay.
Back to slide 12.
No, we're on 11.
11?
Yeah.
My apologies.
Yeah, it's okay. Okay, so now the burning questions. Roadmap to reopening. What does this mean? What do the regulations say? What are we to expect in terms of what we can do right now, what we can expect in the future? So as of right now, the province has created a tentative plan. We're in stage 1. You can see there some of the general rules that they've applied based upon the number of vaccinations, first stage vaccinations versus people who had both vaccinations, how much they're opening up the spaces versus indoor spaces. It's still very generic. I've included 2 links in this presentation slide that you can take a look at, which the government has basically taken their general information out of the regulations and provided some sense of the different areas and how they will reopen. I will note that the majority of their commentary is on areas where there's a lot of person-to-person interaction, restaurants, gyms, public services, things like that. So, take that in stock when you're looking at what the restrictions are there. They might not be the same for your business. We'll discuss this some more, but one thing that is still continues to be the case within the regulation, as far as I haven't seen a change, is an encouragement to keep people working from home if possible, and only asking people to come in if it's absolutely necessary to your business needs. I expect that this will probably be something that will carry through to stage 3. There's some debate on that. Really, at this point, I can't say much more than that. It really is an ongoing basis. They're updating the regulations on an almost weekly basis. You can go to the next slide, please. Okay, so yeah, PPE restrictions are very likely to remain as they are right now as we progress through the reopening. There may be more direction in the future about some loosening. So for example, they might say, okay, you can take down the plexiglass, or, they might say, you don't have to be as stringent with X, Y, or Z. But as far as things go right now, the province is taking a very precautionary approach. Their view is to maintain masks, sanitation, screening, social distancing, all the things we've already discussed. So that's probably nothing new to most of you. And I would encourage you to continue doing the same until there's more concrete announcements from the government. And likewise, I've already said the regulation has more or less said, keep your workers at home. Keep them at home if they can work from home right now. They're not comfortable opening up the workspaces to the degree of that most of us probably like, until there is more certainty. And at the same time, they're more concerned with areas where public services are going to be needed, where certain kinds of businesses like retail, restaurants, etc., which are really suffering right now, how to accommodate them. Yeah, and to that, reopening is very sector specific. I would like to point out that although we're doing pretty good right now with vaccinations, some of you might have heard in the news that they just ran out of Pfizer for people's second or first shots. So there's going to be a bumpy path here. It's not set in stone. 21 days is the minimum that they're setting for themselves. It's a benchmark system. So that 21 days might expand itself for stage 1. I doubt it'll shorten. And stage 2 and stage 3, similar issue. It really will depend upon the rollout, depend upon what the case counts look like. So don't anchor yourself to that 21-day number. It is inadvisable. You take it with the view that that day count could increase for each stage. Yeah, and in terms of what's going to be the case when we get to the end of the road here and most people are vaccinated, it's very speculative. The government is very reluctant to make any broad statements about what the workplace should look like. We'll do our best to give you an idea based on our research and our own general practice, but we do feel that vaccination will be a cornerstone of whatever we're going to be doing in the coming months. On that note, like I said, keep track of what the government is announcing and update your workplace policies accordingly. If you see anything substantive that affects you, be sure to implement that and also discuss this with your employees. Information is key here. Keep them as aware as possible to help them manage their safety at work as well.
Okay, so now turning to the COVID vaccination of the general population throughout Ontario. Employers, and I'm sure a lot of you sitting here today want to know, what does this mean for your workplace? Is this, is this the way out? And so what we do know is that, as Dilpreet had mentioned, vaccines are now being made available throughout Ontario. It is a bit of a bumpy patch. Supply hasn't always been as consistent, and now there tends to be more of a suggestion that we can perhaps mix and match some of these vaccines, perhaps Pfizer and Moderna, they can mix and match. We're not going to profess to be any experts on the health or the epidemiology around the vaccination or the efficacy of the vaccines, but we will just sort of generally cite what we do know from basic media reporting and public health authorities. It seems that the path forward in terms of getting out of this pandemic are the vaccines, and I'm sure they cannot come fast enough as we are all suffering from lockdown fatigue and we're ready to get back to life as we knew it. And generally, in the vaccines as our path forward, Canada has approved COVID-19 vaccines that are deemed safe for use in Canada, and it's been determined that the health and safety benefits of the vaccine far outweigh the risks or the potential downside implications of the vaccine, and that's of course subject to medical advice. And there are 3 vaccines that are approved for use in Canada, and that includes the Pfizer, Moderna, the AstraZeneca. To date, over 2 million people in Ontario have been fully vaccinated. That's interesting because that's a very high stat. We've made a lot of progress. And the data indicates that vaccines are up to 95% effective in preventing infections or symptoms if individuals are fully vaccinated. People are considered fully vaccinated 2 weeks after they've had the second dose of a 2-dose series, such as the Pfizer, Moderna, or AstraZeneca. In Canada, the Pfizer vaccine is approved for people who are 12 and over. The Moderna and AstraZeneca are approved for individuals 18 or older. And the data is very compelling. It's showing that the vaccines are effective in connection with known variants. A small percentage of fully vaccinated people will still get COVID-19 if they're exposed to the virus. And CDC guidelines still indicate that even if you've been exposed, you've already had COVID-19, that you should still get the vaccine, as the data is still unknown about the strength or the length of time, the duration of natural immunity. So I'd like to talk a little bit about the CDC guidelines coming out of the US. They're not binding or official in Canada, but I think they're going to be highly influential for public health authorities in Canada. I think that we do tend to take a more cautious approach than some of our counterparts in the US. But I still think it's worth noting what the CDC is saying, because the US is ahead of the curve in terms of research and vaccination rates. The CDC is offering hope that once the population reaches herd immunity through vaccinations, we can return to normal as much as possible. And the CDC guidelines indicate that individuals can resume activities as they did prior to the pandemic if they're fully vaccinated. You can generally resume activities without wearing a mask or staying 6 feet apart. And you do not need to self-quarantine after arriving in the US. And if you've been around someone who has COVID-19, you do not need to stay away from others or get tested unless you're showing symptoms. So for those who are fully vaccinated, this does show that there is, it's promising because it indicates that there is light at the end of that tunnel. So the question that I'm sure a lot of you want to know is that, can you mandate COVID-19 vaccines for your employees? And the general answer is no. You know, an employer cannot force or tell somebody what they have to do with their bodies, including taking a vaccine. That's an individual personal health choice that one makes. They have the freedom to make that decision on their own, but that choice does have consequences for workers. While they have the freedom to make those decisions about what to do with their bodies, that doesn't mean that they can decide, you know, what can happen to them in the workplace. I think that there will be implications because employers still need to take all precautions reasonable in the circumstances for worker health and safety. So the individual's freedom of choice has to be balanced against the employer's need to take precautions. And so there are consequences, most likely, for individuals who do decide not to take the vaccine. They may be prohibited from attending at the workplace. They may be required to undergo screening or possibly testing if there's rapid testing available. Employees may be required to work from home. They may be required to work modified hours, different shifts, or be assigned to different work, possibly reduced hours, or possibly they may face the risk of termination, which Dilpreet and I will discuss a little bit further. So those decisions, yes, they can make them, but they do come with consequences. Short of mandating the vaccine, employers can encourage employees to get vaccinated. So employers can play a part in, encouraging employees to get the vaccine. Now, there are different ways of encouraging it. For instance, promoting awareness of the vaccine in the workplace, encouraging staff to get medical advice or healthcare advice in connection with the benefits or the risks associated with the vaccine. They can encourage employees to take a look at public health care guidelines. As well, employers can grant employees time off with pay, and you should be aware that there have been recent amendments to the Ontario Employment Standards Act that temporarily require that employers do grant time off with pay of up to $200 per day for up to 3 days for reasons related to COVID-19, and that could include allowing people to take time off to get a COVID test or to get vaccinated, or if they're feeling ill from the side effects from the vaccine, they are entitled to that paid time off. Those temporary measures are in place until September 2021. It will remain to be seen whether that may be extended. It's possible it could be. Other ways that employers are incentivizing employees to get vaccinated is offering cash rewards or bonuses. There is some precedent for that for when employees get the COVID-19 vaccine. According to recent media reports, many large employers are offering cash rewards. For example, in Amazon in the US, apparently offered an $80 bonus for new hires if they receive the COVID-19 vaccine. Target similarly offered free Lyft rides to vaccine appointments. Raytheon, different employer, they count the COVID-19 vaccine as part of their employee wellness program, which provides up to $200 in annual rewards. In Canada, some employers have followed suit. Just from review of recent media reporting, Olimel meat processing plant, a Quebec-based meat processing plant, is apparently offering $25 per shot for employees who get vaccinated. Other employers, DLGL Technologies, another employer who apparently is offering up to $2,500 for staff to get rewards. So it seems to be that there is a carrot and stick approach, and some employers are really trying to get back to business by incentivizing through a monetary basis, or the carrot approach, to get employees vaccinated so that they can return to work the sooner the better. So Dilpreet, is this one yours or is this one mine?
I can take over from here. Fine.
Sure, no problem.
Okay, so how many employees must be vaccinated before employees can be required to return? Right now, as far as the government is concerned, they are not interested in giving you a number. It is going to be it's going to be a contextual approach, I think, and it's also going to be depending on your locality. Things we already discussed. It's risk, and really, at the end of the day, the Occupational Health and Safety Act is what's going to govern what your safety obligations are in the workplace. So when an employer, after full reopening, decides to bring back all their employees, I think that full reopen after stage 3 is pretty much your opportunity to make your decisions on how you want your employees to come back, what kind of vaccination levels are acceptable to you. But at the same time, we're going to discuss, and I've seen it in the chat a little bit, some people are mentioning, can I ask who's being vaccinated? How can I verify? We're going to get into all of that. But if we could please go to the next slide, because I want to discuss something that is also probably at the forefront of a lot of people's minds right now: liability. People are going to be very concerned as to whether encouraging their employees to get vaccinated is going to create any liability issues. Any cases that we do see on vaccinations historically, the chances of liability is pretty low. It would have to be, in the scope of what negligence, for example, can be applied to. Your employee is going to have to show, one, that they sustained a harm from which they could not recover, and they're going to have to connect it to the vaccine, and then they're going to have to go the extra step to show that you were the reason why they took the vaccine. So that's why, this should be taken from a lens of public policy. This is a public policy health issue. The odds of you getting ill from a vaccine that is getting business back on its feet and keeping the public healthy versus whatever possible infinitesimal adverse side effects that could arise from it, and the employer encouraging you to take something that is in the interest of workplace health and safety, the odds are pretty low that you're going to be sued for that. But one way of really making sure that you've checked all your boxes, and to make sure that you're not enforcing in a very heavy-handed way, is, as Jonquille was saying, make information available to your employees. Even if you require them to get a vaccine for the purposes of your workplace, giving them the information allows them to make an informed decision. It's much harder for them to argue that they didn't know, and that whatever might prospectively have happened to them was in direct relationship to your pressure. I think next slide, please. Okay, can you fire a non-union employee for refusing the COVID-19 vaccine? So this is what Jonquille was referring to earlier. You are free to do as you wish with your body, but that doesn't mean you are free from consequence of your choices. We can go to the next slide. So there are two main categories of people who are going to be able to make a viable argument as to why they cannot get a vaccine. The first is people who have a medical exemption, and the second are those who are going to claim some sort of religious reason for not being able to get a COVID shot. So under the Human Rights Code, employers do have a duty to reasonably accommodate to the point of undue hardship. Now, what does that mean? Reasonable accommodation is very fact-specific, very contextual. Undue hardship is as well. But the idea is, if you as an employer, in good faith, go to your employee who can prove, that's the key word, prove, that they have a medical reason or a religious reason, you can take steps to work with them to try to accommodate that need. So what could that look like? For example, if you are unvaccinated and you come into the workplace, your other employees might be concerned this person's not vaccinated, even though they might be exempt under the Human Rights Code. You can still use PPE. You can still use social distancing measures, plexiglass, all the things that we've discussed, all those tools that exist in order to accommodate that person within the workplace. And I'm anticipating some of the questions that are popping up here, so we'll get into that. But Now, what does a medical exemption look like? How do I evidence this? It's pretty, the bar's pretty low on proving you have a medical exemption. Really, a doctor's note's all that person really needs. If there is a doctor who has sat down with a patient, has looked at them, has, in their professional opinion, decided that this person is not a good candidate for a COVID vaccine, which are not very many cases, and that person writes something to that effect to you as the employer, that will probably be enough. That does not mean that you need to bend over backwards on every last request that they might have. Your job is to try to reasonably accommodate them. And again, that is very contextual. So I wish I could give you more on that, but it will vary according to the type of work that person is doing, the kind of workplace you're at, all sorts of factors. So I just saw here that someone said, can you ask for a doctor's note? That's effectively what I'm saying. You're going to have to ask that individual to medically prove that they have a pre-existing condition such that they cannot get a COVID-19 vaccine. That is a reasonable request on behalf of an employer. It also fuels well into your health and safety obligations in the workplace. Now, religious grounds. This is where the territory gets a little murky. You know, there are no, as far as I know, no vaccine-related religious exemption cases that exist out there. We are aware of some cases of people refusing blood transfusions in the medical context, and that being considered an exemption according to their religious rights. But what constitutes a religious exemption, again, will depend upon, one, that person showing you, this is my faith, this is the articles of my faith. You know, I don't know if any of you have heard about this, but there was a case of the Church of the Flying Spaghetti Monster in the United States some years ago, where someone had basically fulfilled all the criteria for a religion under their code. In order to say, yeah, this is according to the law, what a religion is, these are my faith, these are the things that I follow. There are similar, not exactly the same, but similar rules within the Canadian legislative and common law areas that will say what a religion, what constitutes a religion, and then beyond that, what constitutes their practice or belief that is essential and central to their faith. It can't be something that's just preferential. It has to be really to the core of who they are and how they express their faith. So for example, for Sikhs, that might be wearing a turban, right? You get the idea. But ultimately, you're going to still be able to do an investigation on that front. You don't have to just take it at face value. Someone can't just come into you and say, oh yeah, this is against my religion, therefore I'm not doing it. Okay, well, let's discuss that in more detail. The kind of evidence that you might need from that might vary. It might even involve you doing your own research, consulting a professional who knows. But at the end of the day, approach it in good faith and approach it in a way that you're the most informed as you can be to address your employees' concern. Okay, so let's say they're not refusing the vaccine for a medical reason, and they're not refusing it for a religious reason. They may have some other concern or personal preference as to why they do not want the COVID-19 vaccine. Now, like Jonquille was saying earlier, as an employer, your duty is only to accommodate people who are covered under the Human Rights Code. You don't have a duty of accommodation to anybody who falls outside of that. Now, if it's practicable for you to suddenly start dismissing everybody who's going to refuse a shot, that might have cost consequences for your business. I mean, you know, if you have a business of 40 people and 10 of them who aren't covered under the exemptions just suddenly decide they don't want to get a vaccine, that's 10 people that you have to dismiss and probably pay severance packages or something to that effect. So you'll want to weigh it according to your needs, according to the safety of your workplace, if you can figure out a way to balance that. But ultimately, you don't owe an obligation to your non-unionized employee who does not fall under human rights exemptions to maintain your contract of employment. So if you feel that it's not in the interest of your business to have people who are not COVID-19 vaccinated, then it's your decision if you want to proceed to keep that person or if you wish to terminate, so long as you follow your statutory obligations in doing so.
And just on that note, we're referring to non-unionized employees. There's a different ballpark or different framework when we're dealing with unionized employees, which we'll talk about in a little bit. So,
Yeah.
you know, what I expect, oh, sorry, Dilpreet, were you going to say something?
No, I was just going to start on the slide, but if you had a comment, please go ahead.
Okay, so turning to the next slide, I expect that a number of employers are going to deal with a lot of hesitancy on the part of staff to return to work, whether they may be or not vaccinated. And one of the questions that employers have, I expect, are whether you can terminate a non-union employee for refusing to return to work because they may have COVID-19 fears, whether considered valid or not. So there is a process for dealing with work refusal. So a refusal to return to work is in effect a work refusal. And the reasonableness of a work refusal is likely to depend on a variety of factors, including the nature of the workplace, proximity to other people, including workers, visitors on site, the health measures that may be implemented at your workplace, whether the individual is vaccinated, and it could also, you know, what also may be relevant are transmission rates in the local community. And the process for a work refusal is essentially very simple. So if an employee is refusing to return to work, they're essentially, you know, it will be treated as a work refusal under the legislation. And the individual would have to notify the employer. The employer would have to, in that case, assess, you know, what is the basis for the work refusal? Is there a health and safety concern here? And if it is valid, then the employer will be expected to take whatever measures or procedures are necessary to deal with that health and safety risk that the individual has identified. If it cannot be resolved internally, then the employer or one of the workplace parties involved must notify the Ministry of Labor. The Ministry of Labor will appoint an inspector who will assess the workplace risk and concern. And if that inspector ultimately determines that the work conditions are unsafe, then they're going to be issuing directions for the employer to take certain measures to ensure that the health and safety legislation obligations are met. Otherwise, if the Ministry of Labor inspector determines that the workplace is safe, then the employee is required to return to work. The employer can insist that the individual return to work, notwithstanding the fact that they may have a genuinely held belief or concern about their health and safety risk. So the bottom line is, if it's determined to be safe for employees to return to work, then employers can require that employee's return in accordance with provincial guidelines and directives. Now, it's interesting to note that most work refusals during the pandemic were inspected, and most of them were denied. So there were a lot of people saying that they were concerned about health and safety risks, but ultimately most of those complaints were ultimately denied by the inspector. Now, for unionized workplaces, there are significantly more restrictions put in place on the part of the employer to terminate employees for either refusing the vaccine, or if they may have certain concerns about health and safety in the workplace. Ultimately, again, if it's determined to be safe, the employer can require that they return to work. But what do you do if you have a unionized workplace and you have a unionized worker who refuses to get the vaccine? Can you just fire them? Well, there are collective agreement restrictions on the right of an employer to dismiss an employee unless there is just cause for dismissal. So refusing the vaccine, as Dilpreet had mentioned, is probably not cause for dismissal. So what that may mean, even though the reasons for refusal, whether you agree with them or not, because it's a very personal decision that one makes about their body and what they put into their body, including taking the vaccine, will probably not be considered cause for dismissal. So what does that mean? Well, the employer, is particularly unionized employers, will have to consider and canvass potential other options short of dismissal. So for example, is there a reasonable alternate work that the individual could be assigned to? Could they continue reporting into report to work from home? So consider whether or not they can still fulfill their essential duties from home. Perhaps a modified work schedule can be implemented such that they may be working either reduced hours or hours when there are fewer individuals in the workplace. You may insist that they wear PPE, and maybe it is safe for them to return to the workplace unvaccinated with mandatory PPE or personal protective equipment. They would have to follow most likely physical distancing measures. It's possible the employer may have to consider reassigning them if there is other work available. Or otherwise, if there are no practical options in the workplace, then perhaps the employer can consider and may have a right to put them on an unpaid leave until such time as the person can return to the workplace. And generally, whatever options are available to the employer should consider the employee's safety, their individual safety, as well as the safety of others who may be unvaccinated in the workplace, the employer's collective agreement obligations. The employer should generally consider implementing whatever measure that's taken that will have the least financial impact to the employee, and determine how can you maximize their safe participation in the workplace where possible. Now, the next question that we expect most of the audience to have is whether employers can require that employees return to work once the province is fully reopened. And generally our answer to that is yes, but in accordance with provincial restrictions. So when and how your workplace can open will be dictated by provincial orders and restrictions. Once the province fully reopens and the risk level is contained, employers can probably mandate employees to return to the workplace. Working from home is not a right. It's not a freestanding right that employees have, save and except certain scenarios where they maybe have to, where the employer may have to accommodate them for medical or religious reasons, as Dilpreet had mentioned. But working from home, employers can require that they return to work. While employees may prefer to work from home, particularly those with longer commutes, but the bottom line is once the province does clear workplaces to reopen, you can require that they return to work. You don't need their consent to return unless a code-related concern is triggered.
Okay, so I've seen this question a few times in the chat already. So let's deal with the privacy issues. Can employers ask for proof of vaccination? This is something that you definitely need to consider because one, like we explained, you have your workplace health and safety obligations. You want to make sure that not only do you feel safe at your workplace, but the people who come in feel safe. What's probably the most substantive way that people will feel safe is to know that everyone is vaccinated. Now, you probably can ask your employees whether they're vaccinated or not. The thing that you have to be mindful of is your privacy obligations in obtaining that personal medical information of your employee. Think about it like any other time that you get any kind of medical information from your employees, you know, a sick note or anything like that. it's your obligation to make sure that that stays, one, confidential, and two, you explain why you're asking for that note. The same restrictions apply here. If you ask an employee for information as to whether they are vaccinated or not, you should do it, one, in my view, with a signed consent that clearly states what you're collecting, why you're collecting it, how long you're going to hold on to it for. Could be indefinite, but you should say that. And for what purpose? Really, just your answer would be health and safety, just to monitor and just to ensure that their information stays confidential. The employee should be fully aware of all the parameters under which you are collecting that information and agreeing to it voluntarily. You should under no circumstances try to coerce your employee into signing a consent or try to create any impression that if they don't consent to signing and disclosing this information, that it will in any way adversely affect them, whether in the workplace or otherwise. So yeah, and like it says here, health and safety and the need to verify people's ability to be in a healthy environment is a public health concern. It's unlikely that many courts or judges or any other kind of decision maker, and like some of the cases that Jonquille was mentioning earlier, that they wouldn't at least consider the seriousness of the public health perspective on this issue. Yeah, we can go to the next slide. So yeah, and the last thing I would say about this is that now, what do you do if someone says to you, well, no, I don't want to sign this consent, and I don't want to tell you whether I got the vaccine or not, figure it out. Yeah, you can't force them to give you that information, but you can make a decision based upon your lack of knowledge about their vaccination. I would treat them as an unvaccinated employee. As far as you're concerned, if you don't know if they positively got it, your only choice is to treat them as if they didn't get it. And we've already discussed, what you can do in the circumstances in which you have unvaccinated employees who may want to return to work, but are unwilling to get the shot. So you will have to canvass your options. Likewise, on the privacy end of things, your employees might approach you and say, okay, well, I want to know who has a vaccine and who doesn't. Well, your answer is very simple there. I cannot disclose personal medical information of other employees. You might get away with giving a more generic response, this percentage of our staff has been vaccinated. But generally, you'd want to avoid anything that would indicate that you are aware of any person's individual medical information. Yeah, okay, we'll forward this off to Jonquille.
So it's one of the questions I think that individuals or workplaces have are, there are two ways to reach immunity. There's immunity through vaccines, and then there's immunity through natural immunity, having caught COVID. And so if an employee says, well, hey, I got COVID, why do I need to provide proof of a vaccination status? Are they still required to provide a proof of vaccination as a condition for returning to work? And bottom line is, we're trying to give you our best educated guess on this, because there really is no legal precedent. There's no law that says one way or another what to do, or any arbitration decisions that we're aware of that deal with this issue. But, I think in the absence of a vaccine passport, if they have natural immunity, I think at the very least, the employer is going to require some type of medical documentation from their treating physician to indicate that they have natural immunity. Not saying that that's going to be the standard that is expected, but I'd say if that is something that is considered permissible, at the very least, the individual is going to have to provide some sort of convincing and compelling medical documentation showing that they have immunity. The problem with natural immunity is that the duration of natural immunity is unknown, and it's unknown as well based on the science, whether it's protective against known variants. They have more concrete data as it relates to vaccines as opposed to natural immunity. And based on what I previously mentioned, the CDC is still recommending that even if an individual has had COVID, that they should still get the vaccine. So it's not clear yet whether natural immunity passports are going to be considered acceptable. What's interesting is in the EU, they do have a version of the vaccine passport or immunity passport that also does take into account natural immunity. It appears early indications are that it may only be valid for about 6 months. So I think it's more of a stay tuned, but it's possible that, as long as there's adequate medical documentation that indicates that there's immunity, then that might be sufficient.
Okay, so does an employer have to disclose whether a coworker has been vaccinated? I believe we've already covered this. But again, it's important to note that your employees don't have a right to know. That's the important thing that you should take away from that. The importance of you collecting that information is for the purposes of you managing the health and safety risks in the office. Moving on. Okay, so this question is probably in the context of when we have full reopening, does an employer still have to mandate the use of personal protective equipment? So your answer is mixed. Yes, but only where it's necessary. Now, even reading the chat, I'm seeing mixed views on taking the vaccine, people concerned about what the long-term effects might be. So, I mean, in the province's view, in an ideal world, they'll have 100% vaccine compliance. But the reality is that that's probably not very realistic. You're going to have a handful of people in any given business who are going to, outside of an exemption, who are going to refuse. So, until this threat is contained, the government provides some more clear direction. And even then, and this is a discretion of a business as to how they want to maintain health and safety within reason, you can ask employees to wear PPE within your workplaces. The main concern from the province's perspective is to keep a high level of protection such that the risk level is high. The risk level goes down, but your view to your business's risk level, depending on the context of what you do, your interactions, your concerns, that's discretionary, and you can consider other options. So it might not be required for the people who are fully vaccinated, though. People who come in who are fully vaccinated, you tell them to wear a mask, that is probably not going to fly. But if you, like we've discussed, if you have unvaccinated people, you can probably still ask them to take certain precautions, especially for the safety comfort of others. I've seen in the chat, some people have mentioned, if you've had a vaccine, why would you be worried about going into the workplace? It might not be that they're worried about themselves. They might have someone at home who is very, very vulnerable, who falls under an exemption, and maybe they contract the virus through you, are asymptomatic, they go home, and there's a chance that they spread that to somebody else. It's not just about your immediate environment. There's a nexus and connective relationship between the virus and individuals and how they interact. And ultimately, as an employer, you want to safeguard yourself as much as possible from creating any kind of environment where, one, you're the nexus of an outbreak, or two, where people are accusing your practices as the reason why someone got COVID-19. Yeah, and like I said before, and it continues to be the case, so I was going to mention it, but I'll say it right now. The act that we're concerned with here is the Reopening Ontario, in brackets, a flexible response to the COVID-19 Act 2020. And you can just do a quick Google search of that. It'll pop up under the Ontario law, ontario.ca/laws website. They are very good with keeping it up to date. And you can also click on the tab right next to, it'll say right under the name, it'll say versions On the right, you'll see regulations under this act. Now, all those regulations are generally attached to the act. They are updated on a regular basis, and they give you much more detailed rules for what may affect your business specifically. And I expect that as we head towards reopening, the government will use this act to broaden their explanations of what their requirements are going to be and what they think is safe and then what they think isn't.
So what does an employer do if there is COVID-19 exposure in the workplace? The vaccines are highly effective, but they're not 100% foolproof. So under the current regulations, until the province amends these regulations, there are certain reporting requirements on the part of employers if there is known exposure to COVID-19 in the workplace. So in Toronto, for instance, Toronto Public Health, the employers are required to notify Toronto Public Health if there are 2 or more workers who have contracted COVID-19 within a 14-day period of time at the workplace premises. And employers have to cooperate with infection prevention and control personnel from Toronto Public Health, allow them entry, and allow them that there's certain contact information for the purposes of contact tracing that has to be provided to that personnel. Also, the Ministry of Labor must also be notified if there is a work-related exposure to COVID-19, or if there is a WSIB claim for COVID-19 that's been filed by a worker. And where applicable, the employer must also advise the Workplace Joint Health and Safety Committee at their workplace or their designated worker health and safety representative and trade union as applicable.
Okay, so mandatory screening and testing. So screening is something that is probably going to continue being a thing as time goes on, probably even after everything is fully reopened. It's one of the more simpler ways of monitoring any spread. This usually includes, temperature checks, questionnaires that people will do at the door. Now, COVID testing, that is a little more unclear because regular testing might be in breach of some of your privacy rights. I don't know if anyone has had one of the more invasive COVID tests where they stick the swab and poke your brain. It's not comfortable, and there are some less reliable rapid testing methods, but that seems to be the gold standard as far as I'm aware. So whether you're going to require that testing on a regular basis, I think will really depend upon the industry in which you work. I've included an arbitration decision that related to a nursing home, which was a union grievance which was reported back in September of 2020, where, despite nurses who had to be tested every 2 weeks, which became quite cumbersome upon them, the arbitrator still found it was reasonable in the circumstances. It was a public health policy concern. And so that trumped the individual's privacy right to not have a swab go into their nose every 2 weeks. That's probably not going to be the case for every workplace. That's an extreme example. But in others, it might become something where, for example, if you have a scare or there's some sort of awareness through contact tracing, or there was a case at work, it might be reasonable for an employer to ask their employees from their health and safety obligations to get COVID tests before there's any return back to the workplace. And that would probably be the government line as well on something like that.
And before we turn to the next topic about lawsuits against employers, just on that point about COVID testing, I'm of the view that on balance, health and safety is likely to trump privacy concerns, particularly if the testing is not all that invasive. You know, it's a reliable, if it's proven to be a reliable means of assessing whether there's risk in the workplace, I think on balance, you know, I think the law arbitrators, courts are going to find in favor of health and safety concerns and measures being the overriding concern throughout this pandemic. So I think one of the questions that employers must have in this situation is whether you can be sued if a worker catches COVID-19 at work. And the short answer to that is it really depends on whether you are a WSIB participating employer or not, because the remedy that the individual will follow will be dictated about whether they fall under the WSIB scheme or not. So for WSIB participating employers only, if a worker catches COVID-19 from the workplace, and if the employee is suffering physical symptoms of COVID-19, they can submit a claim to the WSIB. And the WSIB is essentially a no-fault system. It's a no-fault insurance scheme. So they don't have the option of going to court. They have to go through this WSIB scheme. And the employees are entitled to WSIB benefits, including potentially loss of earnings benefits. In the case of death, the estate could be entitled to death benefits, compensation for any medical expenses or rehab expenses. And if a person, if they suffer from devastating impact, you know, in very adverse effects associated with COVID-19, if they're unable to return to their occupation, they would qualify for labor market reentry services through the WSIB. But it's important to note that benefits are not available simply because somebody catches COVID-19. First of all, they have to have physical symptoms. So if you're symptom free, just by, you know, if you have COVID-19, that's not going to be a result in entitlement to a claim. So there have to be physical symptoms. And in order to qualify, there has to be some nexus to the workplace. So workers must demonstrate that it arose from the workplace, that it's a work-related transmission. And really, how do you do that with something like COVID-19? Because we know it's highly transmissible. So they could have gotten it anywhere, on the commute to work, going about their daily lives in the community. So it's really impossible to know for sure, but the WSIB has set up a general test in terms of whether somebody may qualify in connection with COVID-19 exposure. And first of all, they can qualify if they satisfy the following criteria. So the nature of the work creates a risk of contracting COVID-19 that is greater than the risk to the general public at large. Okay, so what are the factors that they consider in assessing, well, is there enhanced risk here? Well, has there been a contact source? So has there been somebody in the workplace also that had COVID-19? Does the nature and location of the employment activities place the individual at greater risk? So for example, are they in a section of the city or the province where there's high transmission rates? And you know, they'll look at the nature of the activities. Does the type of work entail potentially close person-to-person contact, potentially, where they're at greater risk of exposure to infected persons? They'll also take a look at the incubation period, so the date of exposure and the onset of the illness. So does it coincide with, in timing, with when they were actually physically in the workplace? And they'll take also a look at the work environment itself in terms of mitigating or aggravating factors by way of risk. So are the job tasks, processes of a nature that might mitigate or aggravate the risk? Is PPE available? It should be, but you know, they'll take a look at PPE and other risk mitigating strategies and measures that are put in place that might reduce the risk of that transmission. What about employers not covered by the WSIB? So I imagine many of you may not be participating employers in the WSIB scheme. So what does that mean? So if somebody catches COVID-19 in the workplace, can you be sued? Well, employees or their estates can bring claims for negligence. So if an employer fails to follow the appropriate standard of care, there is a known duty of care to employees under the common law. And if the employer fails to implement the necessary safety precautions for the protection of workers, then it's possible that you can be sued in negligence. So the question will fundamentally be, has the employer been duly diligent in the circumstances? And it's interesting to note that the province did pass legislation late last year, Bill 218. It's not referenced in the slides, but it's important for organizations to know about it. It's called Bill 218, Supporting Ontario's Recovery Act. And that was passed into law, in essence, to prevent the floodgates of COVID-19 related lawsuits against well-meaning businesses that have attempted in good faith to follow the legislation. So the legislation, in essence, bars COVID-19 related claims or lawsuits against any person, corporation, or entity who's made a good faith or honest effort to follow the regulations. The liability protections, though, do not apply to claims of gross negligence, which is a high bar, and they do not apply, unfortunately, to claims brought by employees involving exposure or infection that occurred in the course of employment. So unfortunately, the immunity protections do not broadly capture or bar employment-related lawsuits. So if an employer is failing to implement the necessary safety precautions or following an appropriate standard of care, then they can be exposed to liability for negligence suits. Ultimately, the individual will have to prove, the difficulty with this is how do you prove that the COVID-19 was transmitted through the workplace? So that might ultimately be a very, very difficult thing for employees to prove in the circumstances, because as we know, the virus transmission, it's highly transmissible in the workplace, and it's essentially an invisible virus. But the best way to avoid these types of claims, whether they end up being successful or not, is to ensure that you're up to date on all of the health and safety precautions and directives that are recommended by the province or mandated by the province, and ensuring that your staff are following all of the health and safety protocols and conducting regular risk assessments to ensure that, because it's not going to be static, and risk may change and vary depending on the status of vaccination throughout the community, depending on whether there are variants and whether the vaccines are going to be effective as against the variants. And it also remains to be seen how long immunity will last, and whether, is it a matter of a simple booster shot that we just take year to year to, supplement our existing immunity? We don't know. I think the science is still very much out on this. So it's going to be evolving, as Dilpreet had mentioned. It's not static, and as employers, you have to exercise your due diligence and make sure that you're regularly up to date on the necessary directives, health guidelines, and protocols. I think it's interesting to know, I mentioned it the last time that I had this presentation, was that there was a class action lawsuit initiated by Diamond for families who had loved ones in nursing homes or long-term care homes that had passed away on account of COVID-19 exposure. It remains to be seen whether that class action will be successful in light of this, and it was initiated before the legislation had been passed. So I think in order for a class action like this to be successful, they're going to have to meet that standard of gross negligence, which is a higher level of negligence than just ordinary negligence. It's a very, very marked departure from the required standard of care. And so, another way of putting it is it's very great negligence on the part of an organization. But I think we'll just stay tuned in terms of what what will come of that litigation.
All right, so just to tie things off before we go into our question period, I thought, we've discussed several times how it's very difficult for us to interpret exactly what Ontario is going to look like when we have a full reopening. But we do have other examples that we can look to that are somewhat instructive, not necessarily what the case will be for us, but can give us an idea of what your workplace might look like. So the United States is probably the most proximate and analogous comparison that we're going to find. They're well ahead of us in terms of vaccination numbers. They're hitting those 60 to 80%, depending on the state's percentages of their populations having received their first vaccination. Their second rounds are regularly increasing in number. But Jonquille went over some of the CDC guidelines earlier, which are a little more stringent in terms of the PPP recommendations, et cetera. But those are not binding on the individual states on what sorts of rules that they're going to implement. As things stand right now, most states in the United States of America do not require a mask to be worn indoors, regardless of whether that person has had a vaccine. That sounds very American, but at the same time, quite unique. It's not something that we might expect in Ontario. There might still be some restriction for Ontarians at that level, that stage. Their bar is a little bit lower on our stage 3 bar. So, some states have recognized this. They're probably a little closer to what Ontario is going to look like in terms of indoor mask wearing for unvaccinated individuals. But for the almost uniformly across the United States, everything is pretty much back to normal, except for a few exceptions on large concert venues, large gatherings, things of that nature. But I think I read just this morning that one state had a Foo Fighters concert with no restrictions, completely open. Everyone's there, shoulder to shoulder, just like things like were before COVID. So we can, I think, reasonably expect a return to normalcy once reopening really kicks in. If I can get the next slide, please. The United Kingdom is probably a little closer to what we're like in terms of our risk tolerance. They have more so taken a more measured approach as they're approaching their vaccine numbers. They are still restricting large events, nightclubs, things of that nature until about July 21st, at least the most recent news that we've seen. They're taking a very relaxed view to PPE in the future, but I have seen mentions where they are putting more resources, more government resources into creating these programs to facilitate screening and testing for businesses across the board. They don't have the state kind of system where they have to worry about every region, whatever the central government mandates or says is the policy or the general guidelines that applies all across their nation. So I think what this is telling us is that once we reach the ends of stages, once most people are vaccinated and we've got a decent percentage of people who've got their second vaccination, we have a good prospect of going back to life as normal for the most part, subject to some screening, maybe the occasional testing in certain circumstances.
Great, thank you so much, Jonquille and Dilpreet, for that very thorough presentation. There are a number of questions. I know you've answered quite a bit during your presentation. Clients, can organizations refuse services to clients unless they show proof of vaccination? And so the connected question to that is, can organizations ask for proof of vaccination from clients?
My view of that is yes. So I think the same standard would apply to any visitor on site, whether it's a worker, contractor, a client on site, that you can require. You can ask for that proof of vaccination.
Yeah, I'd agree with that.
Can employers in the hiring process ask about vaccination status?
Yeah, that's an interesting question, because during the interview process, you want to be cautious in terms of steering clear of any health-related questions or issues, any questions that may pertain to a protected ground of discrimination under the Human Rights Code. I would think yes in this particular instance, because again, it's a health and safety concern, and you got to ensure that whatever, and I think health and safety will trump. I don't see it as being an unreasonable intrusion. It's just like asking, whether it's a new hire or existing employees, just requiring that they are safe to do the work. It's context specific, of course. So if it's something that if the nature of the work doesn't necessarily require that they be vaccinated because it's very low risk, for instance, it's, I'm just trying to think of an example, like outdoor work that might be in the out of doors, which is probably not applicable to anybody here, but that might be a scenario where, well, maybe you don't necessarily need that. But I think for health and safety reasons, just as you would your staff, I think the same rules and principles would apply for new hires as well.
I think you referred to this, but many of the organizations have classroom settings for their services. What's the liability risk for employers if a client or staff was to contract COVID from a classroom setting?
Right. So I don't think the setting will be any different. I think the legislation would bar, well-meaning employers who are trying to, in good faith, follow the health and safety precautions put out by the province. So as it relates to clients, it probably would bar lawsuits. But as it relates to employees, there is no, clear path to immunity. You have to ensure that as long as you're taking health and safety precautions, you can't prevent somebody from bringing an unmeritorious lawsuit. All you can do is defend against it. But to minimize the risk of liability, the employers will have to show that they exercise due diligence in the circumstances for the protection of their workers. So you're not going to be able to prevent somebody from bringing a claim. It's whether, the key question is whether such a claim will be successful. And, I suspect a lot of the educators are probably under the WSIB system, in which case, the whole conversation around lawsuits by employees is moot because it's not applicable. But if there is any employer that's not subject to that WSIB scheme, then you're going to have to show that you're duly diligent and follow the necessary precautions. And whether, that's just sound practice anyway, regardless, right? From a PR perspective, from an employee morale perspective, you're going to want to, and from a legal perspective, you're generally going to want to ensure that you're duly diligent in circumstances by keeping up to date. The best way to show that you're exercising due diligence is, first of all, have written protocols and policies in place, right? About what, the return to workplace will look like, right? Because the first thing any inspector or court might look at is, okay, well, what are you doing? Well, this is what we're doing. Well, where's the paperwork to show that, right? So you should have policies and procedures. You should be designating somebody who's appropriate, responsibility for ensuring that those safety protocols are up to date. So somebody who's regularly checking up, updating those policies, because, given the fluctuating nature of this pandemic, it could change, right? And so the ballgame changes and the standard changes. So having a designated person continually review and update those policies, right? This making sure that they're available for all staff, disseminating it on your intranet through email, making sure you get employee acknowledgements, confirming that they've read the policy, that they understand they understand its terms, and that they'll comply with it, right? And getting those signed acknowledgements, again, is another indication that you're exercising due diligence. So creating that paper trail, and it's not just about the paper trail, right? It's about actually implementing it in practice, but how do you prove that, right? And so you're showing that you're taking these steps, right? To both educate workers, but also set out the framework in which you're expecting employees to follow this framework, and setting out clear penalties as well for anybody who fails to comply with the policies, right? Because they're absolutely mandatory and they can face disciplinary sanction up to including discharge for cause if they fail to comply.
Given that children under 12 are not yet being vaccinated, are there differences in what's expected of employees working with that age group?
Yeah, I mean, that's interesting because I think that's really more of a health related question that might be outside our domain, but there's a lot of reporting that's indicating, and I'm not an expert, that the risk of transmission for kids is pretty low. But that being said, I think you're concerned. I think you got to treat the risk as being present, and that employees, who are unvaccinated will have to take whatever physical precautions are necessary, including potentially PPE, physical distancing, and other measures, plexiglass guards. Those things will still be in place for a period of time. Unfortunately, it's just until the threat level is contained within the community. And Dilpreet, I don't know if you have anything to add to that.
Yeah, I mean, just on what I was discussing earlier with like the daycare issue, right? As the example of one extreme versus the other.
Yeah.
Like I said, you're going to have to do it contextual to your business, right? Or the circumstances in which your employees are working. I know that probably right now, anyone who's working face-to-face in anything childcare related or dealing with younger people probably has to follow very, very, very strict PPE, sanitizing, social distancing is hard, but like I said, you have to measure your factors, right? The ways that you can deal with this. So if you can't maintain social distancing because, kids are harder to manage or, maybe they're not listening or, they're kids, you can't expect the world from them. Not even adults do it. So like you can't have unreasonable expectations. You have to work within the framework of what it is. But that's also why the government has, moved pretty much all schooling to online, even though there are, issues with that. There's, kids being at home, not socializing as much, and why the reopening in September, I have friends who are teachers who are telling me, that there's a lot of concerns. So, yeah, like we were saying about people who are unvaccinated, you have to take the measures that are appropriate to the context. And that hopefully will loosen itself and disappear as time goes on.
For the healthcare sector, is the one employer rule still in place? Policy, not rule. That if you work in a LTC home, for example, you can only work in one employer. The question is, if in a community health setting, can they ask staff to take an unpaid leave of absence if they have a second or third job in a non-health facility?
Yeah, so the sector-specific guidelines, I'd refer the audience to the regulations, but what we can do, to the extent that you have any questions about sector-specific procedures that are currently in place, and you can't find it online, for instance, through the government regulation on the reopening, then feel free to circle back with us. What I will say is I believe that my understanding is that policy is still in place. If there are concerns around health and safety with respect to unvaccinated individuals, one of the options is to place them on a leave of absence if they're unable to work safely. So short of terminating them, right, and there could be restrictions on your collective agreement to do that. If you can't, find some feasible alternative for them to complete work, then yes, you have the option of placing them on an unpaid leave of absence. They would collect employment insurance in the circumstances, or if available. It's unfortunate, but that may be the only safe option until such time as the safety risk is minimized.
Just on what Jonquille was mentioning, so I'd mentioned this, the regulations for the reopening Ontario, and I said it out loud. What I'm going to do right here is I'm going to paste it into the chat. Just let me know if people can open this and view the link. Because what you can do is you can click on the most recent version of the act itself. You can also look at the regulations that are in force under the Act right now, and you can even look at the revoked regulations that are no longer in force. So it is quite dense. It's quite a bit of reading. That's why in the slides I have referred you to the Ontario websites, which create a little bit more of a palatable way of absorbing some of this information. But if you really want to go through the nitty-gritty and comb through everything, you can look at the link that I've sent and look at all the regulations and figure out what pertains to your business specifically.
Yeah, and there's, Jonquille, I know you're reading the chat as well. There's a question around, can we ask parents for vaccination proof for community neighborhood centers? I'm assuming you're saying yes?
Yeah, I suspect yes, because I think the rule is going to apply for all visitors on site. Again, the big disclaimer in all of this is that we're speculating on what will happen, right? I mean, based on the current rules, the framework, pre-existing case law, but this is all unprecedented. But my best guess is that I think it's going to be probably a standard that we're going to, come to live with and accept for a period of time, that people are just going to have to provide some sort of immunity status in order for employers and organizations to ensure that that workplace is safe for staff and for anybody who's visiting on site. So I expect yes.
There was, sorry to interrupt, but there was also one question that I had noticed earlier and I wanted to address. Someone had mentioned when I was discussing the privacy issue that, for example, if you had 1 out of 50 employees who's unvaccinated, still wants to come into the office, and I'm saying, oh, well, an employer can still make them, use PPE or distancing or whatever. Doesn't that in some way discriminate against them or single them out or something like that? I want to make it clear, and some people mentioned this in the chat, that discrimination that falls under the Human Rights Code has to be under a protected ground. It's very clear, things like sex, age, orientation, things of that nature. You as an employer taking steps to create a safe environment, and in part doing that, mandating that an employee, or forget the word mandating, but like working with an unvaccinated employee to try to figure out something short of leave or dismissal, that's something that the employee does on their own voluntary basis. They've made a choice about their personal health. You're not going around handing any information that you might know about that employee to the other employees who might be vaccinated. They put themselves in a situation like that. So whatever awareness other employees gain from that about that person's circumstances really has nothing to do with you. It is unfortunate for them, especially if they're taking that position, but your obligations are to keep a safe workplace and to not discriminate against anyone and to accommodate those who fall within the regulations and guidelines.
Sorry, Jonquille, go ahead.
I just see a question here from Erica about balancing not mandating vaccines with potentially disciplining employees for choosing not to take the vaccine. That's an excellent question. I think the decision not to take the vaccine is not considered culpable misconduct, right? I mean, that's it. What somebody does in terms of their health choices and the choices that they make as it relates to their body and their vaccine status, that's their decision, right? We recognize that they have the freedom to make those decisions. So I don't think it would be cause for discipline or cause for termination, but the employer has a right in the circumstances to say, well, you know what, I have the health and safety concern to ensure that everybody is safe. I have a duty to provide a safe work environment. So unfortunately, that may mean that, we cannot continue the employment relationship, again, subject to code-related concerns around accommodation. But short of that, you can say, well, we're going to part ways. And you'd have to provide a severance package in that circumstance for non-unionized employees, right? Because it's not culpable. It's not cause for termination. That's the decision they made. Probably won't amount to cause. So you can, it's not discipline, but you can take measures to say, well, unfortunately, I got to do what's best for my organization, and I got to do what's best for the health and safety of all the workers. So you may not like this decision, but I'm going to lay you off, or I'm going to put you on an unpaid leave of absence until such time as we think the threat level is contained. Or or we're going to have you work modified shifts. So the employer is going to have broad flexibility to decide what to do in that circumstance, right? You made your decision, you wear that decision, right? You take the you made that calculated risk decision, and so you're going to have to wear it, right? Bottom line. But it's not, I don't think it would be considered from a legal perspective culpable misconduct.
Yeah, Fahima says that it's unfortunate that unvaccinated clients can come into the class, but we as employers can put an unvaccinated instructor on leave. My understanding is that we can refuse service to unvaccinated people. Did I misunderstand that?
Subject to, and again, I don't have all of the information on sectors and what's, non-employment related sectors and obligations that you may have to, to individual participants. But the general premise is that if you can just, like, you can deny entry to an unvaccinated employee, and you can deny entry to, a participant in the program who's not vaccinated, right? Subject to code restrictions, of course, but and that's a very narrow set of people, right? Like people who are gonna need a code accommodation are very narrow. We're not aware of any known religious exemptions. That's not to say that it may not happen, but really you're looking at, for the most part, the only individuals that you're on a practical level most likely gonna encounter who may require accommodations are the individuals who, based on their doctor's recommendations, suggest that they shouldn't take the vaccine. Right, which is a very, very narrow set of people, from my understanding. Even people who may be immunocompromised, their science suggests that they can take the vaccine or certain vaccines. So you're talking about a very, very, very small subset of employees who, we're concerned about code accommodation. So setting all of that aside, if somebody's not vaccinated, you can say, well, sorry, I'm not going to let you come into the workplace because I have health and safety concerns, right?
Last two questions. If time off to get vaccinated is paid time, can the employer ask for verification of the vaccine? And because we know when you get vaccinated, you get a receipt. So can employers ask to see that receipt or to have that receipt submitted?
Yeah, my understanding is that you can ask for that information.
And for those who operate childcare and language classes for adults, would it not be feasible for us to follow similar protocols to that of the TDSB and TCDSB, what they're using? I would suggest yes. If there are larger institutions who have put things in place, by all means, I would crib it from them in terms of policies and procedures.
Yeah, on that.
As long as it's reasonable for you as an organization.
Yeah, on that point, I mean, a lot of what we've discussed today and creating comparisons on what the practical thing to do is looking at analogous circumstances. So, I mean, if you can find something within your industry, that someone who's an industry leader doing something, chances are they've done their due diligence in making sure that they're protecting themselves as much as possible. That doesn't mean you shouldn't go and, get your own advice or consider your own policy contextually, but it can give you some direction on what is possible at the very least. So we're at 12:01. Thank you so much, Jonquille and Dilpreet. This has been a good 2 hours. Thank you for all of your information, your patience. Thank you, OCASI membership, for your good questions. I think we've informed each other as much as we have been informed. Join us on Thursday for our next webinar, which will be on retirement planning. So thank you so much, Jonquille and Dilpreet. We truly appreciate it. We're going to come knocking on your door again in a few weeks as regulations change. Much appreciated. Thank you all. We will be sending out to all of you who registered the slides from Dilpreet and Jonquille, as well as the recording of the seminar. Thank you. Thank you very much. Bye-bye. Thank you, Fatih. Thank you, Selena, for great work as usual. Thank you to our translators who have been doing simultaneous translation. Have a good day, people.
Take care.